pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosing lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the fuck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side, if you know what I mean. I show you shit you never seen, the 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker to walk a green mile. Piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get toes.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Hi. How you guys doing? This was a mistake. You know what? This is a mistake. All right, bye guys. Just kidding. Oh man. Yeah, so I'm gonna try and push through. All right, I'm gonna push through this. I can do this. I'm gonna deal with this madness, and then we got the Elite 8 tomorrow. I'm not high. I'm just half asleep. Apparently, no amount of Red Bull is helping me right now. I mean, if it was up to me right now, I would probably cancel tonight and live stream tomorrow. Tomorrow evening. Serrana's got the good idea. Serrana's got the right idea. She's been very, very clingy. I mean, she's always clingy. She has been. Oh, I'm sorry, baby. Go back to sleep. Go back to sleep, baby. But this is involving Lane Myers. If you don't know who Lane Myers is, he is... I mean, I don't even think he's a First Amendment auditor. He's just like an asshole who acts like a First Amendment auditor. I can't recall the last time he's done like an audit. It's more of he's an asshole who thinks that he's also a loon. He's also like kind of batshit crazy, but he also is one of those First Amendment auditors that think that anybody who works for the government is their own personal property, that they can do anything they want, up to and including harass them because they, God forbid, decided to, be a civil servant. We've already seen his prior stuff of basically a obliterating, verbally abusing the prosecutor as well as the judge in prior hearings, to the point where I'm actually upset with the judge for not like holding him in contempt with the way he acts. But this one, in recently, so right now the story is he's got multiple issues, but the one that's causing the most drama is that Lane Myers has beef with a prosecutor named Matt Walker. Matt Walker, I guess, prosecuted a case against Lane Myers that was ultimately dismissed, I think. Thereafter, Lane Myers accuses Matt's wife, who is a lawyer for like a staff attorney at a university, of getting Lane Myers' wife fired from her clerkship or her law clerk position, I think. And therefore, Lane Myers has had a complete vendetta against Shane Walker because he believes that she is responsible for his wife getting fired as retaliation for winning his case against Matt Walker, the prosecutor. And so a couple months ago, is there anything to that? I'm not honestly not sure. He hasn't really, I have yet to see him provide any evidence substantiating this theory. So I have not seen it, but this is the latest hearing. This was live streamed 2 days ago, involving Mr. Myers. But the thing is, they're announcing that that new charges are being filed against him.
Yeah, it's owned by, hold on, it's owned by Newsmatics Inc., is that correct?
It's
In Washington, D.C.?
You pay them to host the website.
Okay,
That's who hosts the website.
okay,
It's just to do ads and stuff so that you have a website people can go to and stuff like that. And because it's out of Phoenix, they had a local guy. It's just like having an independent contractor.
okay, but I don't really know who this is, and I evaluate
You mean who's here today or in
Who-
general?
in general, who the Phoenix Times, I have to evaluate.
Media company.
It's your media
I
company?
own Freedom Productions LLC.
Okay,
One of my
and,
DBAs.
all right, so this is your company, basically.
It's a DBA, but it's not an LLC.
Okay,
You don't.
Okay.
You don't have to have it registered to have.
Unfortunately, this is audio only.
It's so that we have.
but your company basically opened this website as the Phoenix Times?
My company, Freedom Productions.
I can play some
Yeah.
COD
Which is multiple companies.
while it's playing because it really is
Started that
audio
website so
only.
people had a website to go to, and we could sell ads so that we could have the email Phoenix Times and all that. In exchange for that, that company puts you out there, and then they run those ads on there, and they get ad revenue.
Okay, all right, let me,
We do the stories and that kind of thing, but it's just like a website hosting thing. You know what I'm trying to say? You pay them to market you.
all right, let me hear from the state. Ms. Stiles, your position?
So who do we have here today?
Somebody who says they're from RP Media, which my understanding is a contractor that has been contacted by by somebody to cover this. The Phoenix Times is not an entity. My understanding is just a website that the defendant opened.
Well, the rule's just very clear that there has to be that notice given to the court prior to. So if we're getting somebody else who's filming who didn't provide the notice to the court, they wouldn't be entitled. We're still live streaming. So the recording's still being put out in the public. But if this isn't the person who requested, this company isn't the one that requested the permission, then I think under the rule there.
Right now, they're discussing a motion to permit a live broadcast of the hearings or upcoming hearings.
Automatically denied, is my understanding
Yeah.
from the rule.
I'm going to reverse my ruling from yesterday. This is not what I thought I was approving, and I
Uh-oh.
find it very confusing.
Can I say
And-
one last thing, sir?
Yeah.
Even though I'm not to persuade you to
Whoops.
overturn it, but just to clarify something.
Make your record.
Yes.
Go ahead.
Is there a better way you want us to file that in the future? Because it's ultimately Freedom Productions doesn't have its own website to give you.
Okay. You can file something. I'm not going to give you legal advice. I just did not understand who was making the request, and it was very confusing to me. And I'm concerned about the nature of the charges in this being a harassment case, about who's doing what. So I'm not going to allow. I'm going to deny that for today's hearing.
Can I say something, Your Honor?
Yeah. Hold on. There were a couple of things I had on my list here before we.
Okay, but I wanted to add.
So basically, it sounds to me, and I was listening to it before I went live, that Lane Myers used his DBA to file a motion to be allowed to broadcast the proceedings. The judge approved it, not realizing that the DBA was owned by Lane Myers. So Lane Myers was doing a sneaky thing by trying to get underneath the by not having to make the claim that he's up, that he's the one who's really actually following the ability to broadcast, in a case in which he's being alleged of using his YouTube channel to harass the alleged victim, which is Shannon Walker. So the judge is like, no, I'm reversing my order.
Add to that could change the prior ruling, maybe the reason
Okay.
as well. Your Honor, we still believe that under the 122H, Mr. Myers should at least be able to use his personal audio recorder.
This is Myers' defense attorney. Yes. A DBA stands for doing business as. This is Lane Myers' attorney, but Lane Myers is working to be able to represent himself.
To record the hearing for his own purpose. I think that's what the rule permits. The reason we didn't object more at the last hearing is because the court was going to allow a separate company to essentially film this. We would have concentrated more on that objection and perhaps Mr. Myers would have filed more on why 122H would allow him to do audio recording today. That's a concern because the only reason we accepted the court's ruling without further argument, or Mr. Myers would have filed more motions, was that he understood the court was going to allow some sort of video today. I don't know what YouTube is showing. I don't know where it's being live streamed, how people can access. I'm just not familiar with it.
So the lawyer's trying to save face here, because he's saying, well, we would have made a stronger argument for broadcasting because we were on the impression that a media company was being allowed to broadcast. But now that we realize that it's Lane Myers himself who is who got the permission underneath a trade name, and which seems a little bit dishonest. Now the defense attorney is like, well, we need to make we need time to make a stronger case to allow Myers to broadcast.
I think Mr. Myers at least would like to use his personal recorder 122H to give notice about it and be able to record this hearing.
I deny that. So let's.
Denied.
One thing I want to do quickly, so I don't forget, is Mr. Myers filed a motion to exceed the page limit, which I'm granting. That's for his anti-slap motion. So
Thank you, sir.
you didn't have an order, so I just want to do that on the record. All right. Next, before we address the defendant's motion to represent himself, Mr. Parvin, you wanted to say something.
Yes, it's come to my attention that rather than file all charges at once where Mr. Myers would, I guess, be bailable as a matter of right, this whole situation seems to be piecemeal filing. There are Tucson Police Department officers, I don't know if they're in this room now or if they're waiting outside, ready to arrest Mr. Myers on new charges that will be consolidated with this court, which will therefore deprive Mr. Myers opportunity to respond and represent him pro se, therefore forcing me to be on this case against Mr. Myers' wishes to represent himself. I ask that we be, if the state seems to know what's coming, that since this court has jurisdiction for these new charges, I ask that we do an initial appearance today immediately and set release conditions so that Mr. Myers can continue to represent himself, because otherwise we're going to have a real problem after this court grants this motion, because now he's new attorney on the new initial appearance, and then I'm back in this with the same kind of Feretta motion doing this again. We got a real problem, Your Honor.
Well, so we have a CR pending now. Defendant's been held over, and I'm going to rule on that. I don't know what's going to happen if they're going to file an amended indictment, if there's an arrest and they want to go forward on an amended indictment. There's nothing pending that I could. I understand your issue, but there's nothing there's nothing pending that I could address.
Well, I wonder if the state has any information at all, because considering there's an arrest, that he's going to get arrested on new charges. I just talked to the officers So that's kind of it's going to pose a real problem here. How is Mr. Myers going to respond to motions pro se? And at the same time, how am I going to be withdrawn? He needs representation. And then if there are new charges on new arraignment, the court's going to have to reappoint me again and do this all over again. So again, does the state have any information of all? Because I mean, these officers seem to have information.
Ms. Stiles?
Your Honor, I notified defense counsel yesterday that there were likely new charges coming.
Okay.
And so this defendant just happens to be committing new offenses. And so he faces, just like anybody else who would be ongoing criminal activity would be facing new charges. That's the position he's in. And
Wait,
so
let me ask this. If that occurs and it proceeds and there's an indictment on the new charges, would that be in the CR or a new CR?
it would be a new CR.
Okay.
a
And that would
separate
be
case.
assigned to me because typically we assign all matters to the same Superior Court judge. So, but those aren't pending. Would you agree with me that there's nothing I can take action on with respect to that? It's speculative.
There's nothing that he would have to go through the process, but there's nothing currently that would be in front of the court for the court to be able to do anything on.
But the new charges wouldn't affect these pending charges, correct?
Correct.
It would, Your Honor, because it's going to affect potentially its bail eligibility, and that's a problem if there's no basis for the new charges. That's the whole point of Mr. Myers' slap motion. Now, I would file it slightly differently. Maybe I would have done a motion to dismiss under the or motion to remand once the grand jury transfer comes in. There are things I would have done differently than Mr. Myers, and I would have taken more time to do it. That's the reason I have to withdraw, so Mr. Myers can do everything the way he wants, and he may or may not be, right or wrong, doing it different than me.
Right.
But that's a real problem because if I don't know where the officers are, they work here. I don't know if they're here now. Can give information, but if this court proceeding concludes, we go out there and Mr. Myers gets arrested, brought into custody. He needs a new initial appearance. I don't know when that's going to be. Obviously, the court's going to need back in on it. Are we going to have to reappoint me again and then go through a new withdrawal? And then I'm wondering, at this point, I'm just trying to think for.
Well, we could do a couple things. We could put off your motion if you'd like to withdraw. I mean, that would be the.
But then he needs his motions filed. Sorry.
Hold on. The court system goes in steps, and we're at one step right now. I don't know if he's going to be charged in a new case or not. I have no information on that. But if you in consulting with your client would prefer to stay on now, and then we could reset this, or we can go forward. That's your choice.
I think what's going to happen, as
Uh-oh.
procedurally crazy as this will be, we'll proceed today with the motion to withdraw and Mr. Myers' request proceed pro se. My understanding is all of his motions have been filed, which will prompt the state needing to respond, and that way at least everything's filed. And I'm guessing I will be notified of the new initial appearance. Now, again, I have a calendar as well with my other OCAT cases, and I'll have to rearrange things to try to come to the new initial appearance. I'm guessing I'll be appointed again, and then on whatever new case is, we'll have to be right back here on the new case and do this again. I guess it needs to be done twice, from what the court's understanding is. But we'll do this today. We'll get through it, and Mr. Myers, I will be with you. We'll talk to the office and find out what's going on before you are arrested.
Yeah, I think again we have to concern ourselves with what is currently pending, and I can't speculate as to the different steps in the criminal process. And I don't get the case back until the defendant is held over if there's a new case. So, I think
this is just a very unusual case.
They
Your
did this
Honor.
on purpose.
Hold on. I'm explaining to the court why this. I understand what the court's saying. I just hope the court understands how rare this type of situation is.
it's unusual, but people actually pick up new charges all the time. It's kind of a.
But I haven't done anything.
I understand.
But I haven't done anything.
Themselves and
Right.
respond to motions, but normally, I should say the same attorney can help them while they're in custody.
They're doing this so I can't type at my computer. They just want me away from my computer.
Okay, all right. I'm
For
not.
the record.
we're not
Oh, he's so mad.
That's not our issue today. Today our issue is whether you want to represent yourself. So, and I know the last thing I wanted to mention is that, Mr. Myers, I understand that when you're filing things through our e-filing system, that you're having a hard time marking action for a copy to go to chambers. And we checked on that, and there is only one filing system, and it is possible to mark action by the division.
I
So,
don't know where that is on there.
Mr.
I even called the
Parvin,
clerk and went over it on the screen with her.
Mr. Parvin, have you tried to go over that with him? To show him how it
Actually, on the
works?
filing system, honestly, I've had some issues there as well, where even if it gets there, it goes to a pile. I find it much easier just to deliver directly to the clerk with the courtesy copy, because I know then there's a response that's been received. You don't always know it's been received if you use the action online. But I believe, I understand the court will understand if it doesn't get to him, there's a reason you tried. I don't think the court's going to hold that against you, Mr. Myers.
The only thing I could see on there is it says emergency judicial action.
You don't need that.
Right.
There is a way to do it. It's just always, I should say, more complicated.
I don't know if it's because I'm pro se and they won't let me just send things directly.
No, it's only one system.
Well, it won't matter now because they're going to arrest me and play games.
Mr. Parvin, what would you? I wouldn't. If you have problems with the system, how do you do it?
Well, it's not that I've had I've never had problems filing anything.
Right.
I've had problems where it thinks it sent it to someone, but it doesn't. Maybe it gets it's just on someone's desk or doesn't get printed out, or it's in a list of documents.
Sounds like they're talking about
so
the,
I find it best, although
their
as an
filing
attorney,
system.
it's easier for me to just follow up with for example, the state or the chambers and say, did you get this? And sometimes I say, could you please email me a copy? And that way I have it. But I understand Mr. Myers' situation is a little different. I think it'd be best to use the system where it gets to your court at some point, and if the court does not have it, I inform Mr. Myers it's still filed on time, and then the court would just explain, okay, it's not going to use that against Mr. Myers simply because it finally got to you at a later time.
So the issue that, I mean, it's important that we get copies. What I don't want is for Mr. Myers to email us all this stuff that's not just a document. If we don't get a copy, we don't know it's filed. We don't keep a running, we don't look at every case all the time.
Right.
We take action because something's served on us.
And that is the problem I've had before when I thought I didn't follow up and I thought it was served on court and it wasn't. Again, it was easily fixable because we just got an extension of time limits. But I understand Mr. Myers' concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation unless it's by email.
All right, so I'm going to amend my order from yesterday that Mr. Myers can provide a courtesy copy. When you email me, Mr. Myers, you also have to copy the state prosecutors, okay?
I guess.
Yep.
All right.
I feel like this hearing is.
Hold on.
What do you mean you
We're
guess?
just talking about procedures.
I know I'm going to get arrested when I walk out, and they're going to try to hide me from my computer. So I can't even.
You're
So
going to get a new hearing on that.
how am I going to be able to even file anything in this case if I'm in jail?
I don't have any jurisdiction over that. We're talking about this case and what we're doing today. I don't.
You know what's going on. You saw the slap. It's going to be a slap in the.
So Lade Myers is upset because he can't stop being an asshole. And so they got new charges on him, and he's complaining that, hey, the consequences of my own actions is preventing me from effectively mounting a defense. Well, maybe. Well, you got two options in front of you. One, don't be an asshole. That could find you getting more charges. Or two, get an attorney and allow him to file motions on your behalf. And then the attorney can do all that for you.
The next one.
The court's not going to read everything in 30 seconds.
Okay.
It takes time.
Mr. Myers, we're talking about procedures in this case, okay? I'm trying to help you so that you can hold on, so you can represent yourself.
But I'm
And
more than-
hold on. You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a procedure so that you can file things properly so that I get notice. But I don't want to hear the arguments and the invective towards the other side.
I don't.
So I will amend my order that when you file something, you can email the state's attorneys, Ms. Stiles, all right? So you should never email something to a judge without the opposing party knowing about
Talking
it.
about like when you add the names.
Yeah,
Oh my God. Does he not? Oh my God. Did you actually just ask that? This guy doesn't know how to CC people, how to copy people in a basic email? And also, like, he doesn't realize that when you're filing something with the court, you have to copy the plaintiff, and he wants to represent himself.
CC, yes.
And I'll suggest, Mr. Myers, no commentary. What I do, you simply add the motion. You say, this is what the motion is in the body. That's it.
Right, then we'll make sure we have it.
The fact that his defense attorney has to tell him that should tell you something.
But I don't want, you've added a lot of stuff in the motions that,
Yeah, because this
Yeah,
is
he
all
does.
BS case.
okay, but it's not
Yeah,
proper.
see, so-
I can only consider what,
Yeah, so what is the what is it, this is like compulsive behavior? Like he does not know how to like rein it in. I don't know what else you call it, like.
what's
I
filed
understand.
in the court file.
I understand what you're saying. 100%.
All right, so are we ready to proceed to the defendant's motion to represent himself?
Yes, Your Honor. Mr. Myers, you have filed everything, right? So even if you're brought in custody, you have nothing else to file at this point.
As to the motion to represent yourself.
You're talking about the motion to represent myself.
Right.
I filed the notice of appearance with you. That's what we're
Okay.
having
I'm saying
hearing
even your
on.
slap motion's filed.
My
Everything's
slap
filed.
motion's filed, but I had other stuff, did Rule 15 and all that, but they knew what they were doing. This is dirty
Okay.
tricks.
I think everything's filed, Your
Yeah,
Honor. We could
compulsive
proceed.
abhol
That way
disorder.
you're not harmed.
My thing is if you let,
I'm not smart for proceeding.
I don't know, he was saying that initially a few minutes ago that, there was an option of, waiting a little bit to see, because, they might pull more tricks out of their sleeve. So the thing is that in order to make sure that I have an attorney, but my thing is I'm loath to do that because I want the slap motion heard immediately. So if I don't go pro se right now, that would delay you being able to act on the slap. You know what I mean?
Correct.
But it's also knowing that you left the house today with your wife's car half fixed,
What?
and now I got to go to jail. You know what I mean? And my wife can't get to work as an attorney in town because this is the level they want to take it to.
Oh my God.
I don't know. You know what I'm saying? What's gonna?
Okay.
Because
I have a
now
suggestion. Hold
now
on.
I have
Hold on.
serious concerns about these people being ethical.
Your Honor, I will accept the appointment on the new charges, considering the fact it'll be a separate case number that will address that. That way I'll be appointed when you on the new case to brought to custody.
Will it be brought
and you can
in?
Still, eventually. And then we'll do this again on the second
So
case.
yeah, there are no new charges pending.
Yes, there are. They're waiting in the hallway.
Hold on.
No.
You'll get an immediate court date on that.
There's a process. If you get arrested, then there'll be charges filed. They'll take it to the grand jury. If there's a true bill,
Well, how
you'll
would
be
I-
It's the
arraigned.
one where they got 10 days to get the grand jury. Okay.
So there's the new charges are not before me.
They're gonna arrest me when I walk out.
Also, I have a question. Does he even have a wife? I'm actually being serious. I don't think I've ever seen a picture of his wife in all of the videos with him. I mean, this guy is that batshit crazy that this could actually be all in his head.
It's not before me.
But then I'm gonna go to jail and I won't be able to talk to you.
Myers, I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately, it's not yet filed, which means you have to go through the process, which I believe I told you.
Okay, so
about
there.
10
Okay,
days.
so
car
you
sitting
know.
out there.
Okay, just want to make
We're
sure
here
that
on
that's
Why
waiver.
can't you be
the thing.
respectful and professional?
I'm trying to be.
No, not me and you. These over.
We're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm not. How am I going to be able to respond? If you say if you need further briefing in the slap or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. We won't work that way. I'm not going to. No, it doesn't work that way. You're not going to be prejudiced in this case because you've been arrested on new charges. Okay?
Yeah, they're going to say that I committed a felony while I'm felony for a bond.
That's
You'll get a
different.
hearing
for
on
making
it.
a meme.
That's different. That's different than your slap motion. All right.
Well, I'm going to put a new one on the next one.
Okay, you can do that if there's
Okay.
new charges filed. That's not what we're here for today. Let's
Well, I'm
really.
scared that if I give up my right now, I won't be able to have it in the next case.
Have you right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new.
So you get a new attorney in the new case, and then you can waive your right to that attorney,
Okay.
and you can file a slap motion in that
So
case.
there'll be CR over here,
Correct.
judge whatever, judge or you maybe you.
Same
Okay,
judge.
so it'll be 14 over here, whatever the new over
Again,
here.
my understanding is the concern was I'm not ready to file a slap motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently. And which means if I stay on this case, technically the court
what I'm saying.
has to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay. All right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. And I'm going to ask you some questions about your waiver of right to counsel.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Have a seat. Mr. Myers, I'm going to ask you a bunch of questions. Okay. And it's just the rules I have to follow before I can make a decision to allow you to represent yourself. And they're very standard questions.
Okay.
And it's from Criminal Rule 6.1. Okay. So, do you read and understand English?
Yes, sir.
What's the highest grade you finished in school?
12th.
Graduate high school?
Well, I have a
GD?
no, I have a college diploma and 2 technical degrees, a paralegal degree that I got in prison.
Okay.
Sorry. I shouldn't be laughing that hard about that. Come on. Oh man. All right. Sorry.
Are you under the influence of any drugs, alcohol, or medication?
Right now?
Yes.
No.
Right
Have you ever
now?
been diagnosed with a serious mental illness?
No.
Really?
You have the right to counsel for all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yeah, so I can go back to a lawyer.
Correct.
Right.
If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you going forward?
Thank you.
Is that yes?
Anytime moving forward later on, I can go for myself for a little while and then say, you know what, I want a lawyer.
Right.
Motion?
Yeah, you would file, or you could just say in court.
Okay.
All right. So do you understand you have that right?
Yes.
All right. Next, I want to talk to you about the risks of self-representation. First of all, I want to go over the charges. So you've been held over for trial on an indictment that was filed on March 7th, and there are 14 counts to that indictment. Counts 1 through 6 are each Class 5 felonies. If the state can prove that you've been convicted of a prior offense, it takes you out of first-time offender status and makes you a Category 1 offender, which means you're not eligible for probation. So if you're convicted, prison only. Each one, the mitigated range is a quarter of a year, that's 3 months, and the aggravated range is, on count 1 is a quarter of a year to 2 years. That's a Class 6, and then the others are all Class 5s, counts 2 through 6, where the sentencing range is a half year to 2.5 years. And then counts 7 through 13 are Class 1 misdemeanors, no prison available, there is probation available, or I could sentence you to 6 months on each. And as to all these, some of them may have to run at the same time, but some can run one after the other. So you're facing a substantial amount of prison. And then the last count, count 14, the stalking is a Class 3 felony. Again, if you're a Category 1 offender, the sentencing range is prison only 2 to 8.75 years. So you're easily looking at the possibility of of a long time in the Department of Corrections. Do you understand
Uh-oh.
that?
Can I say something back?
I want to
No.
know if you understand that.
Yeah, that's why I wanted to clarify something you said right at the beginning of that
Uh-huh.
little section
Uh-huh.
about the felonies prior.
Okay. And you're under oath, and anything you say can be used
I know, I
against
was
you.
wondering if
You're a prior convicted felon.
you meant, do they have to be in Arizona?
No.
Okay. Yes, I
have to
understand.
Well, okay then. Now we know that you are a convicted felon. You just were convicted in Arizona.
They have to be within a certain time period.
Yeah, they're 26 years
Hold
old.
on. There is a way to strike it, but that's down the road.
Okay.
Okay.
So to answer the question corresponding to that little segment, yes, I understand.
Okay. Now, if you do represent yourself, you'll be held to the same standard as lawyers. Do you understand that?
All right, not gonna lie. This is actually listening to this BS is actually waking me up. I actually think I needed this.
Yes, sir.
And you, I believe you have a paralegal degree, you said, but you understand that you're a lawyer. Mr. Parvin has attended and graduated from law school and has practiced as a lawyer for a long period of time. Do you understand that?
Yeah, my wife was a judicial law clerk for 8 years too, till they got her fired in this case.
Okay. So
Oh, so mad.
what I'm saying is, if you're represented by a lawyer, you'd be represented by someone who went to school for a long period of time, has
mad.
practiced for a long period of time in this area, and has a lot of knowledge and wisdom and experience that he can bring to bear in representing you, that you're just simply not going to have by not being a lawyer. Do you understand that?
Yes, sir.
All right. If you represent yourself, you'll have to do certain things like pick a jury. Have you ever picked a jury before?
Yes, sir.
You have? Okay.
And I won the case.
All right.
Ooh, I
you have
won
to
the
make opening and
case.
closing statements, and you'll have to cross-examine the state's witnesses and examine your own witnesses. Do you understand that?
Yes.
And you may find it difficult to make arguments to the court. Again, if you watch your lawyer do it, he's very professional and smooth, and it may be harder for you to do that than it is for him to do that. Do you understand that?
I do.
No, Deacon. Theoretically, the charges against him that the victim's husband was prosecuting, they ended up getting dismissed. The whole basis for where we're at now is that he thinks that the prosecutor's wife got his girlfriend fired from her job in retaliation for the prosecutor losing his case against Lane. That's how this is all happening.
You can go to school for 10 years and still not have ethics, though.
Okay, but that's not the question before us today. The question is
snarky.
training and experience. And what I'm trying to tell you is that if you represent yourself, you're giving up a resource of someone who's very trained in this area. Now, currently, you're out of custody, and I understand that maybe you'll be in custody. If you're in custody, as the case proceeds, it's much harder to prepare your case
Obviously.
than it would be for your lawyer to prepare your case. Do you understand that?
I do, and that's why I'm trying to figure out why couldn't they just do this all at once?
Okay. And things that are hard to do would be to subpoena witnesses, review disclosure, and interview witnesses. Do you understand that? Although we will make provisions to try to make that as clear as possible. It is just more difficult if you're in custody. Do you understand that?
Yeah, I understand the game.
It may be harder for you to file papers in court. Today, we've talked a little bit about the difficulty, and we're trying to mitigate that, but you understand it may be difficult to file papers in court as compared to your lawyer who does it all the time.
File with court, you mean if I'm in jail?
No, just generally. Just being
You mean throughout the litigation?
yeah,
when
just being a pro se person,
Yeah.
it may be harder for you to do it
Get
than
them in and stuff. Right.
all right. And then when you represent yourself, you're going to have to stand up and argue to the jury, and in your presentation, you may have less credibility than the lawyer would have. Do you understand that?
Not in this case, but yes.
All right. Well, do you think? I'm just telling you that's a possibility.
I
I'm not.
understand the optics. Yes.
All right.
That's what you mean, right? The optics of it.
Yes, exactly. The service of an attorney can be of great value in determining whether the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence against you is lawful, including the lawfulness of any search, seizure, or police questioning. If an act you may have committed actually amounts to the crime for which it's charged, or if you have another valid defense of the charges, or if you're found guilty, whether you should be placed on probation, required to pay a fine, or sentenced to a term of incarceration, and whether appellate review could be justified. Do you understand that? That service of attorney can be of great value in determining those matters?
I do, and if it gets past the slap motion, you never know. I might have to get one.
Okay. And as we've gone over, if you're found guilty of the offenses charged, that you do have face the possibility of being sentenced to a term of incarceration, even though you've given up your right to an attorney. Do you understand that?
Yes, sir.
Having gone over the risks of self-representation, is it your choice today that you still wish to waive your right to an attorney in this matter?
In this matter.
In this matter,
Right.
this CR matter.
Not whatever they're going to do out there.
Correct, this case, this
Yes.
pending before us. And the answer to that is yes?
Yes, sir.
Has anyone promised you anything if you waive your right to an attorney and decide to represent yourself?
No, sir.
Has anyone forced you or threatened you in any way to waive your right to an attorney and decide to represent yourself?
No, sir.
Have you had the opportunity to discuss your decision to waive your right to an attorney with the attorney that's currently representing you?
I have. We didn't know this was coming, though.
Okay, but again, do you think you need to talk to your attorney more before you decide to waive your right
Not
to a
in
lawyer?
this case.
Okay,
I have one concern, Your Honor.
Sure.
Is slap motion can be done any time, and that's the only concern I had. I didn't really feel comfortable filing that. What has a time limit that I'm worried about is a remand to the grand jury. I don't know when the transcript's coming in. That is a motion I would strongly recommend looking into filing. I don't know if Mr. Myers is capable of filing that motion in custody or even knows when he'll get it, but that's a strict time limit that really can't be waived by the court, although you can get extensions. I know how to do that. Mr. Myers may or may not know how to do that. That's my only concern. But again, I'm not going to file that slap motion. That's Mr. Myers' motion. That's why I need to be withdrawn. I don't know if there's a way to appoint me as advisory counsel and give me permission just for that one basis to look into the grand jury and file that one motion only.
well, if I grant his motion, I'm going to appoint you as advisory
As
counsel.
advisory, can I still file that motion on his
Well, hold
behalf?
on, no, because then you're his lawyer. Hold on. What's the deadline for filing motion for remand is based on what date?
So it's 45 days after they receive the certified transcript, so.
Okay, and you haven't received that yet?
I'm not, but I'm worried Mr. Myers in custody would not know how to do that. I would. That's my main
Okay.
Yeah, I
concern.
know.
I could extend that
Of
to
course he
60
doesn't
days.
know how to do it. He doesn't know what he's doing.
Ms. Alves, do you have any objection to that?
No, and like I said, I don't know when the transcript's going to be ready, but they still.
Okay, all right.
We're not up against that timeline, so if they need more time even than that, we can always keep
Yeah.
adjusting it.
So for today,
But can he file it, or does it have to be me?
It has to be you.
It has to be me.
But I will buy you time. I'm giving you time. Sorry.
yeah, okay. So what we're going to do is today I'm going to enter an order, and I am ordering that the defendant has 60 days to file a motion to remand once the defendant receives a certified copy of the transcript of the grand jury. So that's 60 days. If we're bumping up next to that, then Mr. Myers, you'll have to ask for additional time, okay? What?
If I'm in jail and they mail it to my house, I mean, how would I even know I got it?
Don't you,
How many copies, even though advisory?
So the clerk's office sends out the copies, but we'll make sure that he gets it.
Okay.
He'll get access to all his.
yeah, if
disclosure.
you're advisory counsel, I believe you continue to
I
receive.
get notice of court dates. I don't know what the rules of disclosure are for that.
Okay,
So we will make sure that Mr. Parvin also has a copy of everything, so he gets everything so that he can go and discuss it with his client. So even though Mr. Myers is representing himself, he has his advisory counsel. So we make sure that we're still sitting things through Mr. Parvin.
okay.
But that's not really representing myself.
Well, do you not want me?
Well, no, I'm
you got
saying-
it right. You could get me off.
I'm just trying to make sure that, like, if they're going to send stuff to him, is it what then he gets it to me?
Yes.
So-
He's your advisory counsel. He'll still be able to communicate with
But
you.
I'll also get sent a copy, right?
You should, correct.
It's going to send to both, is my understanding.
Yeah, there may be, if depending on his custody status, there may be different things with the media, but like we work with that all the time with people who are in custody representing themselves.
Okay.
So he will have access to everything.
The next thing is,
You hear
Mr.
that, right?
Yeah.
You heard what they said?
Yes.
Yeah, they're dirty.
Mr. Myers,
He's so mad.
to waive your right to counsel under the rule, you also have to sign
He's
this
so
notice of
mad.
waiver. So Leah, can you hand that to him? And it's on page 2 that you sign it, and I sign it as well, and then it gets filed with the clerk.
Corrupted demons.
All right. The defendant, Mr. Myers, has signed the notice of right to waiver of counsel in open court. We'll put that date on there. The date is the 20th. Court makes a finding that after discussing the matter with the defendant and have observed his demeanor, that he has knowingly, intelligently, and voluntarily waived his right to counsel. The court will appoint Mr. Parvin as advisory counsel, and then we will talk about the schedule here. So there's that. That gets filed in open court. And
Your Honor, I don't mean to interrupt. I just got a text message. Someone mentioned they can't hear any audio on the broadcast. I just want to make sure this whole thing was recorded with audio.
yeah, it says it's streaming active.
Okay, I'm not
So,
sure why I was sent that text message, but it's just what I was told.
okay.
Just can't hear any audio on the broadcast.
Well, we can all hear it.
All right. Let's look at the schedule. So we have a motion to modify conditions of release scheduled for the 27th. And as to that, Ms. Stiles, I'd like, if you're going to present evidence at that, which I assume are videos, is that right?
That's correct.
Could you provide those copies to me beforehand so I can watch them beforehand, so we don't have to just sit and watch all of them? And then you're obviously going to disclose copies to the defendant as well, correct?
Yes, absolutely.
Okay.
Your Honor, how would I prepare for this in jail? Or you just told them to disclose all this. We went on. They could have told me this yesterday. They knew we were setting this hearing. They knew that I needed the evidence. We went over this yesterday. We made a big whole stink about making sure I had the disclosure so I could have due process ahead of the hearing. And now I'm just being a completely I was just appointed and under the understanding that, you know, after this hearing today, they would provide it to me and I would go home and start getting, you know, preparing for next week. Why they couldn't just bring this up at the next conditions of release hearing, you know what I'm saying? So that I could actually make cognizant arguments, because now they're just going to give you, it's like, I'm not even, the evidentiary hearing is a hearing on the merits of their motion. Like, I don't even get to make arguments because they're going to put me in jail and avoid me. That was the whole point. I wanted you to order them to disclose it to me. And you said, well, we got time for that. Miss Stiles, make sure you disclose it to him so he has time to get ready for the hearing next week, right? So they're saying, so all of a sudden you just asked her right here in open court, Miss Stiles, I assume you're going to be showing me this, that, or whatever. Could you send it to me, right? So that implies to the court right now that they knew as of right now what they're going to send, or yesterday or any of that, and they could have apprised me of this ahead of time, but they're waiting to right now to put me in jail, and then they're going to show you the evidence. I won't get to prepare for the hearing. I'll come there looking like a dumbass in a clown suit, and then they'll be like, oh yeah. I had no time to prepare, no time to
You
argue,
are the
and my
dumbass in
lawyer
a clown
can't prepare
suit.
because I just took him off the case. This was all a setup. They could have.
Okay. So, Mr.
Set
Myers,
up.
a couple things.
Bitch, set
First
me
of
up.
all, if you're in custody next week, then there wouldn't be a need for a motion to modify conditions.
What are we doing?
And so we would put it off. Or if you're not able to prepare for it and we're there, you can tell me that you've been unable to prepare for it. What the state said yesterday, though, was all the videos that they're going to use come from you. So you've actually seen the videos.
I don't, but that doesn't, sir, that's not process. So I'm supposed to assume which ones they're going to use? I don't know I make hundreds of videos. So that's like saying we're going to use something the color blue.
Okay.
That's not properly telling me. Now, if they're talking about for the whole case, like in the 14 counts, that's what I assume they meant. But if they're talking about specifically to prepare for the evidentiary hearing and they're going to bring up videos there, they need to tell me, because those are different. Because remember now, this is a hearing for the conditions of release, which means things that happen after the indictment, right? So now I can see for the things in the indictment, absolutely I should know because I have the indictment and I could read it in the police reports and all that, right? But I'm not. But the conditions of release hearing are things that have happened since then. I haven't been indicted, or I haven't been. You get what I'm saying? Given disclosure specific to. Because when they filed their motion to modify, they didn't include no exhibits, no nothing. There was just, hey, we just want you to take our word for it. Trust me, he did this. And so, and it was not even him, it was somebody else. And so what I'm saying is that how do I, not for the indictment, which is, like you said, you got time for that. Specific to this hearing, now they're going to put me in jail. And they could have, it seems like they know what they're going to present yesterday. Like she said in open court, it's going to be videos of me. Then she should have had no problem saying, it's going to be the video that you made called this. It's going to be the video you made called this. It's going to be the video you made called this, or posted on this or that. No, videos. I got 586 videos.
Okay.
Which one?
So, Mr. Myers, at the hearing next week, if you have not been able to prepare for that hearing, we can put that hearing off. I don't have to decide it next week. So,
And
you
Your Honor,
understand?
may I respond?
Sure.
Your Honor, so we've already been sending out the paper disclosure that has the information about all the videos that we have. We also are preparing, I believe it's going out today if it hasn't already gone out to Mr. Parvin, but we're sending him out, and now Mr. Myers will make sure he has access of all the videos that we're referencing. I'm also happy to provide a list that I can send to Mr. Myers that specifically identifies each video that we're going to be doing. So even though he produced them, we're absolutely disclosing them, which is required that we disclose those to him, and we're absolutely doing that. We just couldn't give them all, immediately because we have legal obligations to do redactions.
So, Mr. Myers, when we come back next Thursday, if you think you haven't had a chance to prepare, we can always bump the hearing.
Yeah, because I've asked her 5 times for that. She said she has it now. What paper? She's mailing it to my house while I'm in jail. This is a game.
It's
I
a
don't suppose the court
game.
has Friday available, so I can come too. I'm trying to pick a date when I would have more time. As advisory counsel, Thursday is a really heavy schedule for me. If the court can do Friday on the 28th, I have an open schedule that day.
Well, the reason we said it yesterday is then we also had the victim's input, and Mr. Parvin was here. I don't understand what happened to the
Things
dates
have
since
come
yesterday.
up, and I was withdrawn. If Mr. Myers needs me, I think the question is
Advisory counsel, right?
Except advisory counsel, he should have been preparing to be there because advisory counsel should be at all the hearings.
We were, but we didn't know that. Now I'm going to go to jail today.
Okay, hold on. So you'd rather do the 28th than the 27th?
That way I don't know how long. It sounds like it's going to go longer than I expected. And the Friday, I have an open calendar where I can be here as long as it takes.
We still have 5 days notice for the victims.
I can text
Okay.
right now.
Is she going to contact the victims right now?
Yeah,
Okay.
she's going to reach out.
All right, let's wait for just a second on
I
that.
appreciate it. That way, if it does go 2 or 3 hours, I'm still available.
Okay.
That'd be only a quick half an hour here.
Sounds like they'll make it work.
Okay, so we're gonna change the hearing on the state's motion to modify conditions of release from the 27th to the 28th, and that will be from 2 to 4:30. I'll have set aside for that. Okay, so, and again, Mr. Myers, if we get there and you can explain to me why you're not ready to go, then we'll address that, and obviously Ms. Stiles can respond to that as well. And your slap motion is pending before me right now.
So me getting arrested or anything won't This case can work independently from them arresting me when I walk out?
Correct.
Because you need to see that, please. While I'm here, can I stand up for a second?
Sure.
You know, the slap motion isn't really something the criminal side of it isn't something that's really well defined yet. So like it's not really even in the rules of procedure. So I don't even know, is it going to be a standard 10-day? Because it's not even something they're required to respond to unless you order them to.
Correct.
So I don't know, is there a set period that you have to make your ruling
60 days.
before you order them whether to respond or not?
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And if I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making them respond, I'll also get that out fairly quickly. So.
And also, my understanding is you can rule on it without an evidentiary hearing, or you kind of, if you.
Correct. I could rule on
I
it.
would prefer to have one if, you know what I mean?
All right.
Unless you feel, you know what I mean?
Well, I have to make that decision. I've started to look through it. It's pretty long, like 25 pages or something. So I haven't read the whole thing yet.
I know.
Well, it's not your fault. I'm just saying, I started to look at it, but I haven't read, because you have a long paragraph as to each count.
Right. That's the only way I could do it. That's why I had to exceed, because it's like 15 pages for each count.
I'm not criticizing you.
79 to 80 page motion.
I'm not criticizing you. I'm just saying that it's going to take me a while to read it all and have to decide whether to order the state to respond or not. And I know, as you said, that it's new to include criminal actions in this anti-SLAPP, but it's there, and we'll address it. Okay, and that's what happens. Maybe you'll be making some new law here.
That's what all this is about, because I'm the only one being charged for these videos. There's 500 videos of the same person that nobody else is being charged with except me. There's video. So what I'm going to go here, I want you to hear this right on the record. I'm going to go to jail right now, and there's going to be more videos made in the next 24 hours about the victim than there has been made in her entire life. So I'll be sitting in jail, and there'll be 500 new videos about the victim. She's going to get 500 new emails,
Myers,
500 new memes made about her. How does that protect the victim? It doesn't. This is a
Oh, dude, really? You're really saying this in open court? You know what? I'm going to keep on harassing her. Take that.
charade.
Well, it may be.
You better charge every single person. And I want you to address this on the record, because you said this yesterday, and we kind of talked about it for a second. Slow down. I thought you said sit down. I apologize. All right. So I would like to address this, something you said yesterday, because it's very pertinent as the matter. You're the trial judge, right? And so, you know, I don't know when I'll be able to get back to my computer to notice adjudicated fact, but you ordered me, not asked me, you ordered me yesterday to remove your email from public posting, right? Because Gina's email is not, you know what I mean? And so, but in the period of time that it was up, right, you did receive emails, right? We went over that, you know, and I mean, are those people going to be charged with crimes? You get what I'm saying? And so this is pertinent, and I want this on the record, because the judge in this case received emails as a state of Arizona employee at his .state.gov, and nobody's going to be charged for those emails with a crime by the same agency that's charging me for a crime for other people sending emails to some, not even emails I sent. So in this case, sir, will you be charging me with 14 felonies for those emails you received yesterday at Gina's email? Because that's what we're dealing with in this case. I didn't send the victim any emails. Other people did. I'm going to jail right now for something other people did. So in that case, when we come back on Friday, you should have there should be a felony for each email you received, right?
So let me tell you how it works. Do you understand the separation of powers?
I do.
Okay. And do you
Real quick. So SLAPP, I forgot. I know what it is, but I forgot the exact name for it. Strategic lawsuit against public participation. And many states, including Texas and Arizona, have filed what are called anti-SLAPP statutes. It's a way of preventing somebody from suing you for your speech by filing a frivolous defamation lawsuit, libel lawsuit, harassment lawsuit, etc. The problem is, as far as I understand, anti-SLAPP statutes are civil, not criminal. And this is a criminal matter. And I think that's why the judge said, hey, you might be breaking new ground here, because he's filing a SLAPP motion in a criminal case.
understand who makes prosecutorial decisions? You understand that? Who makes prosecutorial decisions?
Not
me.
I know. But I'm saying, so I should expect to walk out there and get charged for those emails you got.
I don't have any idea what they're.
Well, I mean, you would have reported them to the police.
I'm not going to tell you what I've done or not done. I don't charge people.
That's what I'm saying.
I hear cases.
You're appointed by the governor, right?
I'm a judicial branch employee,
That's what I'm
not
saying.
an executive
You're
branch.
not. What I mean is, over at like Justice Court, they get elected through votes.
Hold on. We have 3 branches of government. I'm in the judicial branch.
Right.
I report to the Supreme Court.
I understand.
The prosecutor is publicly elected. She's an executive branch official. Okay?
Right.
She does their thing. I do my thing. Different silos.
Right.
Okay?
And what I'm saying is you as a judicial officer of the state of Arizona, also people can make a video about you on there and say, oh, I don't think he wears nice shirts, or he made, I don't like the ruling he made in that case, right? They're not going to get charged with a felony,
Okay.
but I am.
Yeah.
Right. Again, we're pending, we're addressing the charge.
We are not, but this is a wholly separate thing, though. Again, this is one of those issues that are talked about a lot for when it comes to First Amendment auditors. Particularly First Amendment auditors, and how they like to weaponize their large audiences to harass public officials. But even in this case, I wouldn't consider Shannon Walker to be a public official. She's a civil servant. She's a public employee. How I view a public official is somebody who is explicitly appointed or elected into a position. So a public official to me would be a mayor, a legislator, councilman, assemblyman, Secretary of State, a town clerk, and a judicial officer. And so I consider that to be a public official. I would not consider like a secretary at town hall to be a public official, nor would I consider like the Superior Court, a law clerk for a Superior Court judge to be a public official. They're civil servants, they're public employees, but I wouldn't call them public officials. And I don't know if this, by virtue of her working for a public entity, warrants her this level of harassment. And the way I say harassment is because if you watch just a few of this guy's videos, it is chock full of saying the worst things that he could possibly say about her, while also posting her work email, her work phone, and her work address. The problem is like that all that stuff is public information. I mean, you can't get around that. The same way as a DA's email is public information. But it's how it's being used, and that's what makes this difficult. Is how do you move between, hey, I'm criticizing this official for what I believe is bad conduct, to, hey, I don't like this bitch. Go tell her I told you so.
Charges are pending before me in this case.
That's what I'm talking about. Because I'm being charged for things other people did.
All right.
That might be defenses, but we're just trying.
Yeah, we're not
I just
there
want to make
yet.
sure, because I want to tell my friends to get
The schedule, and I'll just affirm the case management conference of April 15th and the pretrial conference of May 16th, both at 9 a.m. You are ordered to be present at those hearings. If you're not present, then the court can issue a bench warrant for your arrest. Do you understand that, Mr. Myers?
you, sir.
All right. Anything else we need to address today?
No, Your Honor.
Just that the court already said that in the event that jury trial does go, I don't think it will, that we would waive my presence that on April 15th.
Oh, you mean the pretrial, the case management conference?
Right.
And if they need to reset the hearing, we'll be fine with that. We can always work with the dates as we get closer.
Okay,
I don't want
yeah.
to reset it now because I don't think that trial's going to go.
Okay,
That's
yeah.
Why did you say that though?
What?
Why do you say it won't go?
Because things always, a lot of times you get notification, they have to
Conference.
get continued or settled before the actual jury trial date.
Yeah,
That's
I'm not giving up my.
I'm not talking you.
Different case. He's got a different case. Maybe he's got a conflict on that date, but he's saying that.
Talking about in this case, the trial
No,
might
no,
not go.
no. I was talking about a reason why I could probably still be available on the 15th. I'm not going to make continuance unless I know for sure.
In your case.
Right.
Okay, I thought you meant in this case.
All
'Cause
right.
I don't want to continue anything.
I know you don't. That's why.
This shit should have never happened.
With that, we're adjourned and you're excused.
So it's not over yet. Hold on a second. I'll post a picture here. That's Lane Myers. Right there.
But go felony bond and picks up another.
And see, he even has this this title, publicly available public information. Hawk, he's more of a First Amendment auditor than a SOV. Like, heavily anti-government, anti-anything government related.
That he is in fact getting arrested, or a phone call from Lane that he is free. But I'm going to bet on the arrested side. The way that Lane explained it to me, because obviously he saw this coming. It's not as if he's getting, they're getting one over on him and surprising him with these.
Wait, did he actually post this on his you guys probably can't see it because it's too small, but did he actually post this from jail? Going to jail for no bond for someone else's picture. Get me out of here. If they do it to me, they will do it to you. You know whose fault it is.
Things, but the way he explained it was he'll be arraigned on the new charges, and because he's out on felony bond, and depending on if the charge he's catching right now is another felony, if he is if those are the current conditions, if he is on felony bond and picks up another felony, they can hold him without bond. But because it is two felonies, and because they're talking about withholding bond, I'm pretty sure that there is a probable cause hearing for the new charge. So that would be obviously a good thing, because I think the new charge is the felony T-shirt charge. So he's yeah. So hopefully there would be a probable cause hearing, and obviously there wouldn't be any probable cause. So it would go back. It would revert to the prior conditions of release. Now you got to check me on that. I'm not. Check my facts.
Mr. Myers, your thought?
Oh, they repost this?
Mr. Myers, and then you get.
Oh, I didn't expect them to completely repost this. I believe that's Miss Walker.
Thank you. Mr. Myers, your thoughts on all this?
Can I go rebut what some of the stuff she said?
It's your time to make an argument.
Perfect. So, as you said, sir, you brought up the original harassment, however, but because this was a voicemail, that falls under 132916 electronic harassment. And also, in the injunction for harassment statute 12-1809, subsection E, it literally says, the court shall review the petition on file and any evidence offered by the plaintiff, incling evidence of harassment by...
Could you just slow down a little bit? I'm trying to listen to you, but you're going off.
My bad.
Fast.
I would get worried that you're going to cut me off. I'm sorry. The court, this is, I'm reading a section of the injunction for harassment in and of itself statute, 12-1809. It lists them, and then it's what is considered an act for harassment. For the purpose of this section, for the purposes of an injunction for harassment.
All right, I don't think we need to see this again. I think because we all saw it before. I think it's titled on my channel. But as far as I understand, he is currently in jail. And he has not been bonded out. At least not yet. The next hearing's on the 25th. Yeah. But so I'm gonna end it here. I feel like watching this actually kind of woke me up a little bit. So we're keeping tonight's stream on for the Elite 8 at 7 o'clock. It's still on for tonight. Yeah, I'll see you guys then. So I'll see you guys in about an hour and 45 minutes. All right. See you guys in a little bit. Take care, guys. Bye-bye.
you.